Unit to obligatory law of real estate. As previously mentioned, it is extremely important for anyone that wants to deal with real estate and the real rights to get familiar with the relevant national obligatory law concerning real estate. As Kostas Hagianou mentions in the article about land law in Cyprus, the underlying principle of Cypriot land law is that every interest or right over or affecting immovable property is registered and can be traced in the registries of the Lands and Surveys Department kept in the district land offices, one for each of the 5 districts. These include ownership, easements, privileges, rights of way, rights reserved, mortgages and encumbrances, contracts of sale, springs, boreholes, wells, watercourses, irrigation channels and rights thereon, trusts and leaseholds. Hagianou, 2012. This was a result of the General Survey and Registration carried out in the 1920s. The General Survey led to the adoption of survey plans made to scale for the whole of Cyprus, on which each piece of land as it was held then is plotted to scale and numbered. Practically all privately owned land was then registered in the name of the owners and title deeds issued. Each registration and title deed relates to a plot on the government survey plan made to scale and the area covered by the registration, and corresponding title deed is the area of the plot on such survey plan. Moreover, forest land and government land, known as Charlie land, public roads and footpaths, lakes, rivers, streams and natural watercourses are plotted on such plans, and indeed forest land is on the ground marked by distinctive landmarks on its boundaries. No rights can be acquired over such land otherwise than by a decision of the Council of Ministers, Hagianou, 2012. As it is stated, the only rights that do not appear on the land registries are the beneficial interests in trusts imposed by law, for example constructive and resulting trusts, contracts of sale not deposited with the land registry, and easements and rights of way acquired by extended use, that is over 30 years, which have not yet been registered. All these, if disputed, have to be determined by a court. However, the title or rights of a bona fide purchaser for value without notice cannot be defeated by trust imposed by law and contracts of sale not deposited with the district's lands office. The General Survey and Registration and the compilation of a land registry since the 1920s in Cyprus indicate that the history of each registration and of its associated plot, that is previous owners, the way they acquired ownership, the original plot and subsequent divisions or additions, is easily available. Therefore, mistakes related to wrong registration or wrong plotting, which happens rarely, can be traced and corrected. Furthermore, the various rights acquired or abandoned are traceable, and the survey plans enable the demarcation of boundaries with precision. Furthermore, since the enactment in 1946 of the Immovable Property, Tenure Registration and Valuation Law Cap 224, no title to immovable property can be acquired by any person by adverse and conflicting possession against the government or a registered owner. Thus, a holder of a valid title deed issued by a district lands office is for all purposes protected against adverse possession or any other claims. The title deed is a 2-page document which certifies that the named holder is the registered owner of the plot, number of the sheet plan of the location referred therein, the area of the plot, the date of registration, and the easements or rights of way or other permanent rights in favor of or over the plot are also included. Other temporary rights such as mortgages and encumbrances can only be discovered by a search in the land registry. Cyprus Real Estate Law Information. Conditions, Basic Law. In Cyprus, the basic law regulating the rights over immovable property is Cap 224 of the laws as amended, Law Chapter 224, the law on property tenure, registration and valuation. You can find the law and all relevant material at the web portal of the Republic of Cyprus here. Most of the Cypriot laws and regulations are not currently available in English. Also, you can find the law translated into English here. Forms of ownership. 1. Full title. The full title to immovable property means that the registered owner is entitled to the whole interest in the plot of land and can do whatever he likes with his property subject to any town and country planning restrictions. 2. Beneficial ownership. Beneficial ownership confers on the owner those rights which are provided in the trust deed which is deposited with the land registry. He has no title as the registration and the title deed is issued to the trustee who is the legal owner. The title deed expressly states that the property is held on trust. Another form of beneficial ownership is the life interest reservation. This confers on the beneficial owner the right to possess or exploit the tenement for the period of his life while the title is in the name of another. This is usually a course adopted by parents when transferring their land to their children. 3. Leasehold. Leasehold ownership confers on the leasehold title deed holder those rights which are provided in the lease which is deposited with the land registry. Such leasehold title deeds can be issued for long leases, that is 15 years or over, and subject to the provisions of the lease, can be sold, transferred or mortgaged at the holder's option. 4. Undivided shares. Ownership in undivided shares is a singular form of ownership. The owner is registered in, for example, 1/3 undivided shares of the plot of land or building covered by the registration. Such ownership is invariably the result of inheritance, where the heirs, instead of selling the property and sharing the purchase price or alternatively distributing the property, they register the property in their names in undivided shares in proportion to their hereditary right. For example, 3 children of a deceased register a plot in their names in 1/3 undivided share each. Each undivided shareholder has a right to possession together with the others to the whole of the property without a specific part of the property being allocated to him. They can together lease or sell the property. Each one has the right to transfer by donation or inheritance his share, and further has the right to mortgage or otherwise encumber his undivided share. Each undivided shareholder is entitled to sell his undivided shares subject to the other undivided shareholder's option to purchase his shares at the price achieved. Finally, each undivided shareholder is subject to the powers of the Director of Lands and Surveys Department, the Director, to compulsorily divide or sell, if it cannot be divided, the plot on the application of one of the other undivided shareholders. Procedure: acquiring property. Property may be acquired by straight transfer by the registered owner. Such transfer may be by gift or sale or exchange with other property, and is achieved by the signing of a transfer form before a district land office. Inheritance on the application of the administrator of the estate of a deceased person, pursuant to the provisions of an express trust. Division or distribution. A court order which is issued in the most common situation in cases of wrong registration, fraudulent transfers, breach of trust, and breach of contract. In each situation, the land registry will transfer the registration to the new owner and issue a new title deed to him. Transfer fees of 5-8% depending on the value are payable for sales, donations to anyone other than parent, child, brother, sister or spouse. Documentation needed. On the following link you can find information about the documentation needed regarding immovable property and real estate. Application documents regarding building construction, click here. Buying and selling property, click here. Immovable property, click here. Property mortgage, click here. The transfer of property, click here. Costs, fees, prices. On the following link you can find useful information about the rights and fees, click here. You can also find a description and costs valid until 2018 in the subchapter Fees and Charges. In summary, the main areas that there are fees are: A. Transfer of immovable property. Fees on transfer of immovable property are imposed by the Department of Land and Surveys in order to transfer the ownership of the property to the purchaser. Read more here. B. Property taxes. Property taxes imposed on all types of immovable property in Cyprus. Immovable property tax rates. According to a law proposal voted by the majority of the Cyprus Parliament, the immovable property tax for the remainder of 2016 was reduced to 25% of the total tax arising using the current rates, and it was completely abolished from January 2017. Municipal tax. Proprietors also incur municipal tax on immovable property, town rate. This is an annual tax which is levied as a result of property ownership within the limits boundaries of each municipality, with certain exceptions included in the relevant legislation. Inheritance tax. There is no inheritance tax in Cyprus. Capital gains tax. Capital gains tax of 20% is charged on gains upon sale of immovable property located in Cyprus, which is incurred during the year in which the property is disposed of. Stamp duty. Stamp duty is a tax which is charged on certain types of instruments agreements which deal with Cyprus-situated immovable property, irrespective of whether executed in Cyprus or outside Cyprus. As from the 1st of March 2013, the stamp duty levied is 0% for amounts up to €5,000, 0.15% for amounts between €5,000 and €170,000, and 0.2% for amounts over €170,000, up to a maximum stamp duty of €20,000 per instrument agreement. Read more here. C. VAT rates. VAT is imposed on every supply of goods or services at the standard rate of 19%, 19%. No VAT is charged on supplies of goods or services which are exempted under the VAT legislation, leasing or letting of immovable property, the supply of immovable property with the exception of buildings or parts of buildings and the land on which they stand if the application for a building permit was submitted after the 1st of May 2004. Read more here. Where to apply, the Department of Lands and Surveys. Fees and charges. If you want to avoid any legal battles in real estate, you should apply the following. 1. Know how the local legal system works. 2. Prepare and review the right documentation and keep meticulous records. 3. Do not invest in anything without any legal warranty.